Hello, and welcome back to Coin Lady channel. A U.S. district judge recently reversed Judge Analyst's ruling in the Tourism v. Ripple case, which had found that some XRP sales did not constitute security offerings. Meanwhile, Ripple has released 400 million XRP from escrow, surprising onlookers with the cryptic message whether or not the cryptocurrency would ultimately prevail if an additional judge is present. Stay with me till the end in order to get further knowledge. If you think this would be interesting, you should watch this new video right away. Judge Jed Rakoff's latest judgment in the XRP lawsuit, along with the Delta decision, is a major setback. The judge's decision means the SEC can move forward with its case against Terraform Labs and its creator Du Chuan, who had argued that public institutional sales should be treated differently. Twitter user John Reed Stark is responsible for bringing attention to the court's decision in the Terraform Labs case. Former SEC attorney Stark has given Judge Rakoff's ruling on Terraform Labs' motion to dismiss the SEC's action against them. You may recall that the lawyers for Terraform Labs and Du Quid asked the judge to dismiss the SEC's complaint. The lawyers relied on the decision in the Ripple case to argue that the assets at issue are not securities subject to SEC jurisdiction. Judge Rakoff rejected issue or Terraform Labs' request for the SEC complaint to be dismissed in his decision, stating that the SEC has jurisdiction and a strong case that Terra USD, the Anchor Protocol, and Luna may have violated securities laws. In response, the SEC argued against agreeing with Judge and Elisa Torres' conclusions in the Ripple case and declared its intention to appeal the ruling. He took issue with how the Ripple instances handled the gap between private and public sales. He argues that the Howey test does not differentiate between customers based on the provenance of their coins, because all buyers may reasonably anticipate that they would profit from the defendant's efforts. The judge's judgment also questioned the significant question idea, which stems from a Supreme Court ruling that prevents regulatory agencies from going beyond their scope. Some Bitcoin defendants, like Coinbase in their case against the SEC, have used this defense. When compared to other industries subject to government oversight, the Bitcoin industry does not carry the same weight. This argument was shot down by Judge Rakoff. To emphasize the importance of this judicial system, it should be noted that Judge Jed Rakoff is widely regarded as one of the country's preeminent securities law jurists. The former SEC attorney also highlighted Rakoff's reputation for objectivity. David Schwartz, chief technology officer of Ripple, voiced some concerns about the court's decision, saying that it seemed to be based more on the unique aspects of the Terraform Labs scheme than on the fundamental qualities of cryptocurrencies. This is to say that the court's decision to dismiss the Ripple case did not appear to be made merely on the basis of fundamental disagreement with the court's justification. Instead, it depends on the specifics of the differences between the two circumstances. He offered two different readings of the court's ruling. The court ruled against the Ripple decision because it relied on criteria that were not part of the Howey test. Schwartz argues that this is the worst-case situation for people who favor Schwartz argues that this is the worst-case scenario for those who back Torres' choice because it shows that the court may not apply or follow the Ripple rule in this instance. On the other hand, one could argue that the court didn't apply the Terraform Labs case's Ripple finding because of quirks in that action, and not because the ruling had any direct bearing on the Howey concerns at hand. Despite the fact that the details of the Ripple case lend credence to the idea that institutional transactions are separate from public ones. The court speculates that similar considerations may not be relevant in the context of Terraform Laboratories. Schwartz thinks this is the most convincing evidence in favor of Torres' choice. Recent factors have contributed to XRP's price dropping below 70 cents for the first time since July 13. Yesterday's trading below the key support level of 70 cents. The asset's price is currently 69 cents, down 2% from the previous day. If you want to be the first to know about events involving XRP as part of its monthly escrow execution procedure, be sure to hit the notification bell and subscribe to our channel. The XRP tokens held in escrow by Ripple have been released. A strange note was inserted in an escrow execution transaction worth 400 million XRP, leaving the community to speculate on its origin and the identity of those involved. Mr. Intuitive, a prominent member of the XRP community, is credited with popularizing the arithmetic memo. The prominent community member recently tweeted their disbelief and amazement at the message's contents. The note was included in an escrow execution transaction that occurred at midnight tonight. 400 million XRP, worth about $275 million at the moment, were traded. Although the transaction appeared to be a standard escrow execution, the memo stood out. Warm preserves are now sizzling, that CNET is now Lumbo, it says. The rat of the day has been caught in the mousetrap. Will Jeremy's compromised Twitter account and broken dock be repaired? Will television cover the revolution as it gathers momentum toward an official event? I was wondering if the secret sauce was spicy or mild, David. Despite the letter's ambiguity, it does make some passing references to recent happenings in the XRP community. The email references the hacking of attorney Jeremy Hogan's Twitter account. As was previously reported, scammers used the Hoovian's Twitter account to promote news of a phony XRP giveaway. The letter from July 24 questions Jeremy Hoovian's capacity to recover his stolen Twitter account. On July 29, Hogan got back into his account. As a result, you've asked too late. The memo also includes a question for David Schwartz, Ripple's chief technology officer. When should you add the secret ingredient? Does it feel hot or cold? Asks questions. Since the message might have been authored by any employee at Ripple, it has elicited a wide variety of reactions. The style is reminiscent of that of articles written by self-proclaimed regulars in the XRP community. Since 2019, the owner of the address used to initiate the escrow transaction has begun responding to emails like this. On April 19, 2019, a thorough investigation of the address revealed a comparable document in an escrow transaction involving 1 billion XRP. The XRP community is in too much disbelief to investigate the source of the messages at the moment. David Schwartz, who is well known for his sense of humor and interpersonal skills, is at the center of the scenario. Some supporters have already highlighted Schwartz. Most likely, the memo did not originate within the Ripple system. However, bear in mind that given the prerequisites are met. Whether or not they are an employee of Ripple, anyone can initiate a finish escrow or cancel escrow transaction. Even yet, it is reasonable to conclude that the statement was crafted by a member of the XRP community in an effort to garner attention from the broader XRP audience. Without any more information. As of right now, this is all speculation. The new judge will cause a wind of change in the answer to the day's most pressing question. If you want to be among the first to know about any XRP-related updates, make sure to hit the bell and subscribe to our channel. Ripple Labs stated yesterday that they have filed a notice of presence on behalf of former lawyer Douglas Samuels Alcon and seasoned SDMI attorney James K. Fill-in. The litigation against the SEC. The Southern District of New York has received the request to confer and has indicated its willingness to cooperate with one of the law firms representing Ripple Labs in this matter. Document filed yesterday in the Southern District of New York by de Beauvoir and Plimpton LLP. Saw at the law firm of Law and Plimpton, where Ken is a partner, he specializes in litigation. It's worth pointing out that Zol Ken is well-versed in both the ins and outs of government and white-collar defense. He received his education at both Cornell University's Law School and the University of Pennsylvania. The attorneys have extensive experience defending businesses and individuals against efforts to enforce laws and regulations. Socken worked as an assistant U.S. attorney before becoming a litigation partner at VIVY and Plimpton in SDNY. Cybercrime, political corruption, securities violations, and international bribery were just some of the many crimes he directed investigations and convictions for. Members of the XRP community are thrilled by Socken's interest in joining the Ripple's legal team, and his impressive resume has piqued their interest as well. However, his application to join the Ripple legal team also sparked some confusion in the XRP community. To put minds at ease, Ripple's founding attorney, John Deaton, has confirmed that Salkin will be taking over for Lisa Dornberg. Stormberg reportedly became New York City Mayor Eric Adams' chief counsel. Consequently, Sakena is trying to fill a void in the legal department caused by the departure of key personnel. Sockets have applied to appear on behalf of Ripple as the SEC shows intentions to appeal Judge Analyst's summary ruling. In response to the judge's ruling that allows Ripple to be sold to ordinary investors, the SEC has expressed its unhappiness. In her ruling, Judge Torres ruled that the XRP sold through Ripple's programmatic exchange is not a security. The SEC is expected to appeal a verdict that would allow retail investors to purchase Ripple, according to legal experts. It's also possible that the litigating parties will reach an amicable settlement. According to the reports, Judge Sarah Nepper ordered the parties to pick 3 different dates and times to negotiate a resolution. Dawkins' legal expertise will help the litigation's ripple effect regardless of the SEC's judgment. This video has now come to a close, gentlemen. If you liked the video, please click the like button. Be sure to hit the bell icon and subscribe. See you later, bye.